introduction, Bahawalpur, the faculty of the Law of the Islamic University, Bahawalpur, Professor Amjad Hussain of the Islamic University, Bahawalpur. Ladies and gentlemen, Assalamu alaikum. Firstly, heartiest felicitations to the management for arranging such a marvelous function on the topic which has a direct bearing upon the well-being of the society as a whole and for the strengthening of the rule of law in particular. It is a matter of honor for me to address this prestigious gathering. To begin with, Constitution is an act of extraordinary legislation by which the people establish the structure and mechanism of their government and which they prescribe fundamental rights and rules to regulate the motion of the several parts. According to Thomas Paine, Constitution is the act of the people in their original character of sovereignty. Thus, the Constitution of Pakistan, like any other constitution, determines the most desirable way for life for people of Pakistan and creates a government, organizes the government by creating three principal organs of the state, that is the legislature, the executive and the judicial, and defines their powers and duties and creates written boundaries for each of them. Justice Kayani defines the constitutional jurisdiction of the High Court in the words that it brings to a benighted morality, delight that never was on the sea or land, God in his heaven and all's right with the world. God was in his heavens even before the writ jurisdiction, but all was not right with the world. Consequently, if you are spiritually enlightened or inclined, you can say that the writ jurisdiction is the modern manifestation of the God's pleasure, and the God's pleasure dwells in the High Court. In short, while exercising constitutional jurisdiction of the High Court performs duties of divinity. Before the Constitution of 1956, the High Courts in Pakistan exercised jurisdiction conferred on them by Section 223A of the Government of India Act of 1935, which at that time served as the Constitution of Pakistan. Having parliamentary system of government in the country, the lawmakers, in order to demarcate the respective spheres of different organs of the state, have been dividing the constitutions in different parts, in as much in the first constitution of the country passed in the year 1956, Part 9 was earmarked for the judiciary, and Article 170 thereof dealt with the powers of the High Court to issue certain writs. Likewise, in the Constitution of the Islamic Republic of Pakistan 1962, Part 4, Chapter 5 and Part 5 and Chapter 3 related to judicature. In the Constitution of the Islamic Republic of Pakistan 1973, Part 8 has been assigned to judicature. According to Article 175 of the 1973 Constitution, every province and Islamabad Capital Territory has its independent high courts. While following the principle that no person can be left remediless, High Court has been conferred with multidimensional, comprehensive and effective jurisdiction under the Constitution to redress the grievance of a person who has no other remedy. It is of common knowledge that on the one hand, High Court has to deal with the matters arising out of the work and conduct of the authorities functioning in connection with the affairs of the federation, province or a local authority by issuing a writ of mandamus or certiorari or prohibition. And on the other, it has to ensure the liberty of a person who has been detained by anybody without lawful authority by issuing a writ in the natures of habeas corpus. Simultaneously, High Court has to answer a query relating to the eligibility, competence of a person to hold a public office while dealing with the writ of quo warranto. Moreover, High Court has also the responsibility to ensure implementation of the decisions of the apex court of the country in terms of Article 187 of the Constitution of the Islamic Republic of Pakistan, 1973. The most pivotal task to be performed by the High Court is to ensure the enforcement of the fundamental rights embodied in Part 2, Chapter 1 of the Constitution of the Islamic Republic of Pakistan, 1973. Violation of fundamental right is the most frequently used ground for invalidating a state action, legislative or executive. Whether a fundamental right has been violated depends upon the scope of that right to be spelled out of the language of that particular article in Chapter 1 of Part 2 of the Constitution and its application to the facts of the case before the court. In addition to the judicial functions, a High Court has been saddled with the responsibility to supervise the district judiciary on the judicial and administrative side. Judicial superintendence is carried out by way of entertaining and hearing appeals and revisions against the decisions of the court subordinate to High Court, whereas in its administrative and supervisory jurisdiction, the High Court monitors and ensures the smooth and effective functioning of the courts subordinate to it. Further, the High Court has to undertake the process of recruitment, promotion and posting of the judicial officers for the court subordinate to it, in addition to taking the departmental proceedings against a judicial officer to its logical end. Moreover, it has to frame rules for the standardized procedure and process for effective functioning of the subordinate courts. One should be mindful that the above narrated powers of the High Court are not unfettered, rather are subject to law. While dealing with the multiple proceedings, firstly the High Court has to consider that any matter brought before it is covered under the relevant law or not. Secondly, it has to affirm as to whether the aggrieved person has any other efficacious and alternate remedy or not, as the constitutional jurisdiction is only attractive when no other remedy is available. Since the High Court has to strike a balance for the rights of the public at large and duties of the state functionaries, it is supposed to be more careful and cautious while dealing with the matters brought before it. Unnecessary interference of the High Court in the policies enunciated by the executive for their smooth working would amount to usurp the powers of the said organs of the state. At the same time, High Court should not feel shy to strike down any act of the legislature or the executive, especially when the same is found ultra-vires to any explicit provision of the Constitution. Since administration of speedy justice plays a pivotal role in the flourishing of a society, the importance of effective superintendence of the subordinate courts by the High Courts becomes inevitable. The role of the High Courts towards its subordinate courts is that of an elder in the family. To fulfill this said role, High Court should encourage problem sharing by the judicial officers from the district judiciary and resolution thereof through proper mechanisms, and so that all and sundry are able to use it as a guiding principle in the future. Moreover, High Court should have proper check and balance over the district courts through detailed inspection and surprise visits, and if any of the judicial officer or any staff member from the district judiciary is found involved in activities prejudicial to the good conduct of a government servant, they should be taken to task to set an example for the others. Availing this marvelous opportunity, I will share with you that the effective exercise of the constitutional jurisdiction by the High Court apart, role of the members of the bar is very important. During my days in the bench, I have noted that the advocates, especially the beginners and the young lawyers, are not aware of the points to be argued on the preliminary dates of hearing of a constitutional petition. For example, when they are confronted with the question of jurisdiction, as my learned brother had pointed out, regarding the lashes and estoppel, they are found themselves in a error. Though law has developed to the effect that when other alternative and efficacious remedy is available, the constitutional petition before a High Court is not maintainable. And as this High Court under Article 199 is a creature of the Constitution, and we are bound by the dictum laid down by the Apex Court of the country by Article 189. Number of petitions which are filed on a daily basis agitating the matters wherein remedy of appeal, revision or review has been provided under the law. Likewise, the Apex Court of the country in Itazal's Essence case, that is PLD 1989 Supreme Court 61, and the Signal Free Corridor case, that is 2015 SCMR 1739, has highlighted the grounds on the basis whereof constitutional petitions in the shape of public interest litigation can be filed before a High Court, but in a number of cases it has been seen that the advocates opt to file such a petition on behalf of a client who in the garb of public interest litigation wants to settle his personal vendetta. Even in constitutional petitions in the nature of quo warranto, the criteria has been laid down in the cases of Nisar Khan Khatak, that is 2021 PLCCS 140, and Muhammad Hanif Abbasi PLD 2018 Supreme Court 114 is not being followed, resulting into wastage of time of the court. It is well entrenched by now that a writ petition involving the terms and conditions of a civil servant is not maintainable, but despite that, number of petitions are being followed in routine against the spirit of the decisions of the Apex Court of the country, as has been dealt by Khalilullah Kakar's case, that is 2021 SCMR 1168, and Ali Azhar Khan Balot judgment, that is 2015 SCMR 456. It is also very important to highlight that number of lawyers are not aware about the difference between the report in para comments in a constitutional petition and the written statement to be filed by the respondent in the event that constitutional petition is admitted to a regular hearing. Despite the fact that the procedures of the writ petition is governed under the provisions of CPC. It has also come to limelight during my experience at the bench that the writ petition is only maintainable where a right guaranteed under a particular law has been infringed. But certain writ petitions are being filed in routine without caring for such a fact. The aforementioned problems can be addressed by the seniors, arrangement of conferences like this, and necessary training to keep the beginners up to date about the points to be considered before filing of a constitutional petition before the High Court. I have come to know that with some sincere efforts of the representative of the bars, a research cell and a dispensary has been established in the High Court Bar Association Bahawalpur. I hope this initiative would help a lot to the legal fraternity, including the new entrants. I have already instructed the senior additional registrar of this bench that our research cell and our research officers would be in liaison with your new research officers and would give them the guiding principles how to search the legal queries. I conclude with the note that since the constitutional jurisdiction of High Court has great impact on the inter-se relations between the masses and the state, it should be daily exercised in appropriate cases. Likewise, if any action of the executive challenge before the High Court is found to be unwarranted by law, the courts should not hesitate to impose exemplary costs to the delinquents. Once again, thank you very much for giving me an occasion to share my views with such an esteemed gathering. Thank you very much.
Honorable Chief Guest, Honorable Justice Shujaat, मैं रिक्वेस्ट करूँगा प्रोफेसर अमजद हुसैन पवार साहब से कि वो रोस्टर पर तशरीफ ले आए और